Okay, we are now back on the record uh, in the Robinson versus Taylor matter. And Mr. Donahoe, you can continue your questions.
Thank you, Your Honor. I only have a couple more. Mr. Robinson, you can still
Yes,
hear?
yes, sir.
Okay. There was some testimony given earlier about you having a drug problem. Can you explain to the court if you do or don't have a drug problem?
I don't never have one of their tactics. I don't know where they're getting this allegations from. I choose to ignore it myself. It doesn't bother me, but that's what they choose to do. That's on them. I don't have a drug problem. Never have.
Have you ever had a drug problem in the past?
No, sir. No, sir. Never been to rehab or any of that type of stuff. Absolutely not. Had a drug dealing problem years ago.
Have you ever been convicted of a crime dealing with drugs?
Yes, several. Four conspiracies over 10, 15 years ago. The court is aware of it.
And you haven't had anything since? Not
a traffic ticket. I've had a traffic ticket in 10, 15 years. No, sir.
I would also like to ask, do you love your son?
I love my son more than life itself. I'm there for him 100%.
Do you believe the defendant loves your son?
Absolutely. Yes, I do. I don't doubt she loves him at all. I never doubted it in my mind.
And are you willing to work with her in making sure that the court's order, whatever comes out of this, will be followed?
I try to do the best I can. I've always complied with the judge's orders. Sometimes she gets mixed up on dates. Sometimes I do also. She's not totally to blame. It's being late, and sometimes it's my fault. And I try to communicate with her, and we make adjustments like adult parents should, without pointing the finger at each other. That we have to do it for the child,
Exactly.
I'm willing to work with her any way I can. I always have.
Now, lastly, I just want to ask you if there's any other information you think would be relevant to the court in making this decision today.
I'm pretty sure, the judges have seen my track record with the child. He placed him in my custody 6 years ago. He's still here and he's still making progress. And we haven't had any bumps in the road from what I can see. I don't see why anything should be discontinued. Like I said, I would like to see her be incorporated more in his life. If the courts choose to order, other than that, I can work with her. I tried to work with her outside the courts. We're adults, and we shouldn't have to have the courts to make orders like that. There's provisions for other people to be into the courts, and I feel that we should be able to communicate like adults outside of the court and have a general relationship with this child. But Rachel's not willing to do that, and during this time we have a court order, we can't have any contact to communicate together, and if it's a violation for me to try to reach out to her in any type of capacity, so I just follow the laws of the court right now until something changes in that matter. Other than that, I have no hostility towards Rachel. I encourage her and her family all the time to participate with this child because that's their relative. Don't worry about me. Participate with him. He needs to know both sides of the family. I've encouraged that from day one. Never tried to intervene. Never. Not once.
Mr. Robinson, that brings up one more question, I guess. How are you facilitating the transfers if you're not able to have contact with
her sister? The judge ordered her sister. It was Abby, and Abby's pretty good. And she actually just gave me a ride home yesterday because we were getting my car repaired, and she picked us up yesterday when she came to get him, and she notified me that she was in town. I did not tell her to come all the way to Jackson. She voluntarily came because she had other business to take care of with her other children here. And she called me when she got here and said, "Hey, I'm here by a store." And I said, "We're just leaving the barbershop. You want to come pick us up?" And got me off home. But other than that, we've been abiding by the meet at the Miller Road exit where he's ordered us to. And I told you my truck got hit when I was going to pick him up on a Sunday there, and it knocked my front end off my headlights there. So I don't have headlights at night. And they were accommodating me by bringing him closer if they could, which only happened once or twice. And other than that, I did facilitate the visits as the court ordered. And I don't think we had any problems with that. That's Rachel's version, my version, and Abby's version. I always asked Abby, which is her sister, if she had any problems. She said no. She told me no. I just talked to her yesterday. I told her that there's been some allegations made that I forced her to run around town and look for us or whatnot. She said she never said anything like that.
Your Honor, I would object based on hearsay to that statement.
That was definitely hearsay.
Thank you.
Thank you, Mr. Robinson. That's all I have for
you. Questions, Ms. McCluskey?
Thank you, Your Honor. I'll try to keep it brief. So, Mr. Robinson, can you confirm that your phone number is 517-395-8255? 9656.
It's been that way for 19 years now.
Okay, that was my next question. Thank you. You did see that phone number on those, the exhibit that was admitted evidence?
Ma'am, they can put phone numbers on everything. The technology is so vague now. That's what you kept asking her. Was that, has it been altered or whatever? They can alter stuff. They can do so they can put another face on a person's body these days. I don't have time for stuff like that, but they play with the computers. I don't do that type of stuff. That is my phone number, ma'am.
Okay. Gotcha. What exactly are the criminal charges that are pending right now?
Are you asking me, Ms. McCluskey?
Yes. Yeah.
An alleged domestic.
Okay. And you requested a jury. Is that correct?
Yes, ma'am. From day one. Yes,
okay. Okay. So that is set for a jury trial.
It's been set several times. We're doing this COVID. We haven't been able to do it. In almost 2 years, we've been trying to get this going forward. Do
you have a current trial date?
Yes. Come up here in June or July, I want to say.
Okay. So is it your testimony that you're home every night with Camden, despite?
I'm home every day and every night. I drop him off in the morning at my niece's, who's my sister's daughter, who watches him. In the morning, I drop him off, and I pick him up in the afternoon when I get off work. She lives 2 blocks from me.
Okay, so you're never gone for work overnight?
Absolutely not.
Okay. Were you in the past an over-the-road truck driver?
Yes, I was.
Okay, when did that change?
When did that change?
Mm-hmm.
I think when Cameron was in custody, I took him with me for a minute. I took him with me for about 3 or 4 months until he started to develop and stuff, and I felt he needed to be in the home.
Did you say Cameron?
Camden, my son, Camden.
Camden. Okay, right. I'm sorry. I thought Cameron.
Yeah, Camden.
Gotcha. You mentioned that you testified that you're quote unquote getting custody back of your daughter. Is that correct?
Yeah, but you testified opposite. You testified I lost my parental rights or whatever, and I have the letter from the DHS that submitted to the courts already that's stating that you guys have mixed up information. You and Rachel submitted to the court, so I lost custody of Olivia or whatever. I just seen Olivia yesterday, and there's a document from DHS in the files right now. So I'm looking for Jasmine or whoever.
So you did not introduce that into evidence, though?
I submitted it with my attorney. I couldn't submit it to the court. The court sent it back and said it had to be submitted to the attorney so that you could view it also. I didn't have an attorney at that time. He has all those documents from the supervisor.
So DHS.
Yes, ma'am.
Okay. So DHS was involved with you and your daughter. Is that correct?
No, they're involved with my daughter and the mother, who's up there with Rachel. I ain't never had the child. They notified me where the child was, and I stepped up to the plate like I did this one. I've never had the child. The mother had the child. They took the child, gave it to the grandmother or something. Same thing Rachel tried to do. So I'm going to get the child.
Okay. Why is that child not placed with you?
We're doing reunification right now. She's been with a grandmother for about a year, so we're integrating her so she don't come kicking and screaming and all that type of stuff. We have visitations. We just visited with her yesterday. Me and Camden visited yesterday just before Abby came and got him.
Is someone supervising those visits?
Yes, they are.
Okay. So you get supervised visits with that daughter?
That's what's ordered through the courts right now, ma'am. I abide by the court order.
Okay. Are you participating in services through that case?
No, I don't need any services at all, man. There's nothing wrong with me. I'm perfectly normal. I have issues, but they're not to the extreme where I need any counseling or anything.
When was that child removed from her mother?
I cannot. I have to go home and get the documentation. I don't have the documents with me right now. The mother's up there with Rachel. They hang out or do whatever they do up there in the Odyssey house. She's up there in the rehab with her.
But just to clarify, the daughter was never placed with you?
No, she's about to be.
Okay. Was it your testimony that you invited Miss Taylor to have summer parenting time with Camden?
Yes, I did. About a week ago, and they just now responded yesterday or something like that. And I immediately, I invited her to her sister. I don't know how they communicate. Her sister said she didn't get text alerts or something like that. I don't know how that works either. I reached out to them and offered them some time with him in the summer here because he's out of school. And I told him whatever schedule they would choose to pick, I would be willing to work with him. We'd drop him off and we'll took 10 days, 7 days or whatever. I've done that on several occasions. I just gave him to her on Mother's Day. Father's Day's coming up. I won't even have him. She ain't even offered him back, but that's fine. I'm all right. I have him all the time. No problem. I made sure that she had him on Mother's Day. We had her some items made for Mother's Day. We sent those to him. He had made some gifts for her from school. We made a few things around the house we sent to her. I sent 2 of her by him. He wanted to do some things for his mom, so we done it and put in an envelope.
But you're aware that Miss has filed several parenting time complaints, though, are you not?
Yeah, are you aware that I contested those reasons why she couldn't get them? Ma'am, she had a no contact order. What can I do? I went to jail when I did. She put me in jail. She was in jail for 13 days. Okay. She had no contact. I had no choice. I didn't do it voluntarily.
So you do agree that you. Okay, so you do agree that you withheld Camden.
By law, ma'am, I couldn't. By law. I have a no contact. She has a PP order on me. I went to jail. Judge Major put me in jail for 13 days when she got on the stand and told him that I'd give her the child family dollar every weekend. He said, he does what? She said, I see him every weekend. He gives me the job. He said, you got a problem, Mr. Robinson. Put me in jail for 13 days. Mr. LaFlamme seen me in jail on Zoom. He located me when we had a hearing. I didn't even get notified of the hearing because I was in jail.
Okay, thank you. So, Mr. Robinson, did it ever occur to you to ask a third party to do the exchanges as one is doing now?
No third party contact, no nothing. It's in the order, man. Would you like to see the order? I mean, it's public record. He said, no, I can't text her. No third party contact. I'm actually violating by doing with Abby or sister. That's third party. But Mr. LaFlamme ordered that, and I'm complying by him because Mr. Major's off the mention.
Okay.
Like the third party in there too. No texting, no nothing.
Mr. Robinson, I think you answered my question. You testified that you believe Camden is borderline ADHD. Has he been diagnosed?
No, I didn't say he's borderline ADHD. He's borderline a meth addict because she had all that meth in her 2 days before he was born. And he shows high activity and stuff like that. I haven't had him diagnosed. He's perfectly physically normal to me, and he's a normal kid to me. Just energetic. I have a lot of energy, but on top of a lot of meth use, I could see, him having some type of extra boost, okay, which I expect him to grow out of. I'm not a doctor or anything, so I can't diagnose him, but he's a normal child to me. Normal, there's a lot of energy. Now. I'm used to it.
So no diagnosis?
No need one. No, I don't know. From God, he's fine. He's fine. He's blessed.
Okay. Didn't you testify he has some challenges with school?
Yes, he won't, just, concentration, because he wants to bounce around, stuff like that. Energy, a lot of energy. Okay. That's challenging to me to try to get a child to sit down with a lot of energy. It's a challenge.
Is there a reason that you did not introduce any school records or grade records into evidence?
I did. Your Honor, I've already seen him. He just didn't understand. I did. I've introduced him. Yes, I did. I have no problem hiding anything. I've introduced him. Yes, there. They've been in there.
Okay. So you testified that Camden comes home and tells you about all the fun stuff that he does with his mom. Is that correct?
Yes, I don't interrogate him. I just ask him, did I have him to have a good weekend? And he said, yeah. Well, he just recently told me this last weekend they went to a motel and they went to a water thing and he enjoyed that, and she introduced him to a jacuzzi and he enjoyed that. He'll tell me about new adventures and stuff. And they always go to Soaring Eagle or to a water park up there. So that's normal activity. That's fine. It's normal. She does do things with him. Rachel's not a bad person. I'm not saying anything bad at all about Rachel. She does not mistreat him. I cannot say that at all. She loves him to death. She's learning. She's doing all right. She's doing all right.
So you deny regularly withholding parenting time from Ms. Taylor. Is that
one more time? It's because they're cut out on here.
Yeah. You deny that you deny parenting time to Ms. Taylor. Is that?
I don't do it on purpose, Miss McCuskey, at all. I done it because the law said no contact. So this is the third time I said it. I went to jail for it once, and once the judge had her do the meeting place up here, she's had her visits. I think one weekend we got mixed up because I gave him to her for another weekend or something. We might have got the calendar mixed up, and they said they wanted him that weekend. I told her she'd have him the last weekend, but I've also extended his visits throughout this. I've extended. She don't mention that part. She don't mention none of that.
So you testified, you believe that Ms. Taylor works a great deal. Is that correct from your testimony?
I don't believe. I know she does. I've been up to Ms. Taylor's house several occasions. I know she does. She works 6 days a week. She's on call. She has to run the peers around. She has to run her peers around. She has to cater to the place. She didn't get it to the house. She has to do what they tell her to do. She has to.
So you heard her testimony that the boys can both be at work with her. Did you not?
No, you can't. You don't take children to work to a drug rehab. That's not appropriate. She's not there to do children. She's there to recovery coach. She says She's there to recovery because you don't go to teach kid about drugs. That's inappropriate. That's inappropriate to me.
And you mentioned that you allege that Miss Taylor kicked you during this domestic violence incident. Is that correct?
That's correct. He'll tell
To
you
your
that.
knowledge?
Canada will tell you that.
Okay.
Also.
To your knowledge, was she ever charged criminally?
No, I didn't press charges. I didn't know anything about this whole incident until about 2 weeks later when I went to visit my daughter. Her and the other daughter's mother got together. They knew I was going to the visit. They sent the police down there. Okay, this is another one of their stunts. I didn't know anything about it domestic. Nothing. Police never came to me at my house or nothing.
But you are charged criminally.
Yes, ma'am.
You were not too long ago residing at a shelter, were you not?
The domestic violence shelter when she assaulted me, yes. I went to get counseling and then information on how to, assess that situation, yes. I went to the battered shelter for domestic violence. Yes, I was. That's the shelter I was residing at.
Okay. So, but it's your testimony you were not homeless within the last couple of years at one point?
Mr. Robinson, you muted your device. We can't hear you.
I wasn't saying ignore you.
We can hear you now.
Okay, yeah, I was trying to ignore the phone call. Sorry about that.
So it is your testimony that you were not homeless?
No.
At any point in the last?
No.
Okay.
No.
And you did not request, you didn't take money from Miss Taylor for hotel rooms for yourself and Camden?
I don't take money for I don't take anything from anybody. No, I did not take anything. No, I did not.
Okay. Are you aware of Miss Crabtree's extensive drug history?
We don't hang out like that. She told you that we don't hang out. No, I'm not aware of that. We don't hang out. She's like I said, she's a parent of one of my children. And if
you don't hang out, but you had a child with her?
We don't hang out. I had a child with her. Yes, that's right. We don't hang out.
Okay.
The child is
and you
the child
admit
was
that,
what? 4 years old. 4 years old. That's 4 years ago we hung out.
And you do admit that she has cared for Camden in the past. Is that a fair statement?
Of course, she's watched Camden in the past, maybe a half hour or something. If I went up to the store or something like that, yeah. He was outside playing on his bike or something. I didn't make him get off his bike and tell me, yeah, you're right. I went to the store and came right back. Maybe 15 minutes, something like that. No extensive periods. Always daytime, no overnights, nothing like that. I don't leave him overnight with anybody. I'm very, very sheltered about him. Anybody will tell you that. He's with me 98% of the time. 98, believe that. I'm very adamant about that.
I have no further questions at this time. Thank you, Your Honor.
Redirect, Mr. Donahoe.
None, Your Honor. Thank you.
No, we'll call him tomorrow. Okay, I'm not sure about that.
Would appear that we're ready for arguments then. Ms. McCluskey.
Thank you, Your Honor. I'll keep it rather brief. I do think my client's presentation has made our case, but I would note that we received no written response from Mr. Robinson regarding this motion. So we would ask that the court treat the motion as if it was there's no objection. So in short, obviously the court is likely aware that we were in court on my client's custody motion 3 years ago, I believe. And at that time, the court relied on an unpublished opinion stating that a parent's recovery does not meet the burden for a change in circumstances. At this time, I think my client has more than met her burden. I would argue that this is one of the most clear examples of proper cause that I've ever seen. And quite frankly, the testimony established that the change my client is requesting is in Camden's interest. Obviously, it's uncontradicted that the domestic violence is an issue. There's domestic violence that happened in the presence of the child. Mr. Robinson has been criminally charged. I think obviously the most compelling was Miss Sarah Taylor's testimony, and the fact that we say there's undeniable proof based on text messages introduced into evidence that
I'm on the
there
phone with
was
the court now.
the,
Gotta go.
sorry, Mr. Robinson. The actual activity that Ms. Taylor testified to was in fact happening, and it can be confirmed that that was indeed Mr. Robinson's phone. And additionally, that this has happened within the last 2 years, which is clearly since the current order was put into place. And I know that obviously Ms. Sarah Taylor is my client's sister. However, I can't believe any person would ever offer the incriminating testimony that she did if it was not absolutely the truth. She testified, my client and her sister testified to drug use, obviously the prostitution activity. It's just inconceivable that this stuff is happening around the minor child. My client has testified that she was in active addiction when Camden was born, but also that now she is 2 days short of being 5 years clean. She clearly has a very reputable position, a stable job with an institution that I think we all have a lot of respect for, the Flint Odyssey House. Her sibling, Camden's sibling, lives with my client. She testified to the bond those boys share, and the fact that she is able to take the child to work. So again, Your Honor, I think not only has my client met her burden, she's gone above and beyond that burden. And quite frankly, it's just a concern that this child is even still in Mr. Robinson's care. So we would ask that the court grant the relief we requested in the motion and grant a change in custody. Thank you.
Thank you. Mr. Donahoe?
Thank you, Your Honor. The real issue here seems to be that one parent thinks the other is not suitable to have full custody. My client has testified quite succinctly that he is more than capable of caring for the child. Camden has been in his care for quite some time and has flourished. Now, my client has also testified that he doesn't have a drug problem. He hasn't had a drug problem. He doesn't have any mental illness. There's nothing that will preclude him from being a good parent. In fact, he has proven that he's a good parent time and time again. Yes, he's missed some scheduled parenting time. He's made some mistakes in the past with scheduling. Possibly he could have found somebody had he looked maybe a little bit harder to be a third party. But would that have been a violation of the no contact order? We really don't know. So I think he has shown that his ability to parent this child, his love for the child, and the fact that he does everything for this child. He takes him to school, picks him up in the afternoon, plays with him, has a good time with him, and sits down and talks with him like every parent should. So I don't see that there's been any testimony that is credible that would lead the court to believe that my client has not been a good parent. I think overall, he has had some problems in the past. I think more than anything, it's been a communication problem between the parents. And he has even stated that he'd be more than willing to increase parenting time to give the other parent an opportunity to create a better bond. So this is not a good parent, bad parent thing. They're both good parents. They both want to spend time with the child. And the court just needs to make a decision in this case on which one should have the larger amount of parenting time. I don't think custody is necessarily a choice here. I don't believe that there's the necessary hurdle has been crossed in showing clear and convincing evidence that there's been a change in circumstances. I mean, we're talking a 5-year recovery from drugs and drug addiction. Wouldn't that have been clear and convincing evidence 5 years ago when this all began? Why wait until now? So we would just like the court to take all that into consideration when making a decision. And if the court has any other questions, we'd be happy to answer them.
Any final words, Ms. McCluskey?
Just that I obviously the court remembers that the court also interviewed Camden, and we are confident that that interview probably played out how my client assumed it did. And that would be it. Thank you.
Thank you. There are some things brought out today that the court is going to need to look into. Specifically, the request that I take judicial notice of Ms. Crabtree's file. I have a vague recollection of the file, but if I'm going to take judicial notice of a file, I need to review it. I want to look back at the other neglect matters that have been mentioned today and review those. And I want to take the time carefully to review the hearing that took place last, I think it was October, before I issue a ruling. And I will issue a written opinion as promptly as I can. Thank you. Have a good day,
Thank you.
everyone.
Thank you.